The accused is charged with a bailable offense. He pleaded not guilty and as such is presumed innocent until he is found guilty or until he voluntarily pleads guilty. That gives him a right to apply for bail, which right he has triggered today. But grant of this bail is at the discretion of the court. Save for surety number 3, the rest of the sureties are not disputed. I equally find the objection against the third surety also very trivial, and it is accordingly overruled. So the 3 sureties are found substantial. There is no objection as regards his place of abode. I am inclined to protecting his right to personal liberty and the presumption of innocence. Accordingly, this application is allowed. The accused is granted bail on the following terms. You will execute. The accused person shall execute a non-cash bond of 5 million. Each of the sureties is equally bonded with 5 million. It is also not cash. You come back here on 3rd of Feb at 9:30. 3rd of Feb at 9:30.
Your Honor, off record. Off record, Your Honor, I know by next time when we come back, you will not be here. We are aware of the transfers that were made, and we know you're not far, we shall meet there. But we thank you for being flexible and allowing the accused to be produced today. Especially during this festive all the various cases you will be having. Thank you for that, and we wish you good luck in the next session.
Come back.
Can we do that one? Let's leave space for others.
Kawesa Sharom.
L'église aussi pas. Pierre Caroline, Pierre in the States. Which that this person is present in court.
Your Honor, Counsel Sip Maharona. Hearing with Land Sewaro Alan. Gavi Counsel Gavi Connelly. Gavi Connelly.
Gavi.
The worship and Counsel Silwaj Ashraf. Jointly appearing for the accused person. Your Honor, the matter is coming up for bail application and we are ready to proceed.
The state are ready to proceed.
A2 was issued a production warrant. Before I got on the production warrant. Well, A1 was called, but he's absent. He has not appeared in court. Was issued promotion and is on promotion. As per that. This matter is coming up for bill application. And we are ready to proceed.
Let's proceed. I want you to be very brief and precise. Go to the issues, non-issues. They are not
Most of that.
issues. Let's concentrate on issues only.
Most of that. Your Honor, I will bring this application under Article 3, 6 of the Constitution of the Republic of Uganda.
Mhm.
We also premise it under Article 28, 3, which provides the presumption of innocence. Your Honor, the charge preferred is bailable by this honorable court. Your Honor, the accused person has a fixed place of abode, also has a national identity card, which I submit to this honorable court. Your Honor, the accused person is a sole breadwinner, is a family man, keeping him in custody is detrimental to his family. He does not hold any other charges. Your Honor, he will not interfere with the proceedings of this honorable court in the hearing when it commences. Your Honor, the accused person has a healthy condition of being asthmatic. And by the time he was arrested, on the 14th day, before he was arrested, 14th day, had just gotten a healthy problem, was undergoing treatment. Your Honor, I submit a medical report from St. Timothy Medical Clinic. Your Honor, the accused person has sureties who are in court. I invite counsel Conway to present him.
Judge,
Mm.
Your Worship, if I may, I'm going to call you once again.
Mugabe,
Connie,
Connolly. Okay.
we have three sureties in court. And the very first one is the mother, Nakalima Sarah Kayondo.
Nakalima Sarah Kayondo.
Worship, she is aged 54 years. She is a resident of Nakurabi, West Church, Zone 4. Worship, she is also a farmer. And like I say, the biological mother of the accused person. She has a phone contact number 0774 38 428. And this court wanted to engage with the surety. I can proceed to the second.
Just
surety.
present the second sheet.
Obliged.
Mm.
The second surety is Kwizera Ashiba. She is aged 22 years. She's a resident of Obunkenke zone in Obunkenke.
Where are the documents for this surety?
She's into decoration business. And what she most importantly, she is the wife to the accused person. They also have a baby around 1.5 years. They are parenting an infant. Your Worship, she's on phone contact number 0709 97
Come again, 07.
0709 97 6595.
Come again, the number?
0709 97 6595.
Did you upload your documents on Bigamy?
Yes, you are uploaded on
Okay.
that. Our third surety is Mr. Musaz Godfrey. He's a male adult, aged 41. He is a resident of Nagurani West Church, Zone 4. Your Worship, he is also the LC Defense Secretary. He is a close family friend. One, to the family, which is the parents and the children, but also to the accused person. Your Worship, he is on phone contact number 075 2 20
07.
52
Yes.
20 56 37.
37.
Worship, it is our prayer. Court finds the sureties substantial and substantive enough to stand surety for the accused person. Your Worship, as the legal team, we have also labored to explain to them their duty as sureties, which they appreciate. Sureties do understand that it shall be upon them to remind and compel the accused person to attend court as and of when he is needed. If a true court is pleased, find merit in our application. We reiterate our prayer that court is pleased, indeed find merit, and grant bail to the accused person, and preferably, Your Worship, given the economic situation, him being a sole breadwinner who's been on remand with a young family, it is our prayer that court is pleased to grant a non-cash. So pray, Your Worship.
The state has Is there an objection to this bail application?
Yes, yes.
Please proceed. Present your objections.
First, we acknowledge the fact that this offense is bailable. And that the accused person is presumed innocent until proven guilty. And the fact that it is his right to apply for bail. But it is not automatic that once an accused person who appears before a court to plead guilty should be released on bail. Bail is at the discretion of court. It's to be taken note of it. The accused person applying for bail cited grounds for his application. One of it being ill health. And produce a medical report from St. Timothy Medical Center. This accused person, when he appeared in court, was remanded and is coming from prison. And there is no report from prison to say that they cannot manage this condition well under prison or under custody in the hands of the prison authority. That's why we wish to pray that it should be noted that the prison authority actually have the best health facility. It is the best in the country. It manages even chronic sickness. This cannot be handled by the private hospitals. They can still manage. And they have not said that we can't manage him. These are the prison authorities where the situation where they can't manage. They usually make a report to court and even a referral. There's no referral, no report. So I pray that because we can on that ground. Can be ill health which cannot be managed. And also there is a ground of being a brain winner. This is most of these people who are remanded in prison. They are all brain winners. It is to be one of the grounds for each one to qualify to be released on bail. They end up throwing them all out. So yes, it was on that ground. I pray that God ignores it. That's one of the conditions for the accused person to get out on bail. The accused person has produced 3 sureties. Among the 3 sureties, the last surety is one called Godfrey Musisi, the defense. That's why the defense also is supposed to be a neutral person. Neutral, in that it should not come to take either side, at the side of an accused person or at the side of the complainant, because he serves all the interests, both for the complainant and the accused person. Those are people, those are his subjects. Defense is not a small person in a community, he's a big man. You may even say that he's also one of the they are to have a cabinet system, one of the also the ministers at the village level. So those all people who are residing within their subject. But the person also find him not suitable. Stand as a suit for one side. And also in this matter, we actually ready, more than ready to have this matter expeditiously handled. The prosecution is only being frustrated by the absence of one of the accused person, that is A1. Otherwise, the complainant is very ready to come and start commence the hearing. And we're supposed to take note of that. And the event that you also got inclined to grant the accused person bail, it is your own prayer. The terms will be in such a way which will compel the accused person to attend court whenever required, so that the justice is dispensed accordingly. I humble prayer also.
Yes, in rejoinder.
Your Honor, we take note of the objection raised by our land estate. Specifically rejoined on round 3. My colleagues will rejoin on others. Your Honor, state alludes to the fact that the third surety is not substantive, be it that it's a defense and it should serve a neutral position. Your Honor, state has not contextualized the neutrality of the defense. Your Honor, the defense in any area LC, his role is to ensure that he enforces the law. And Your Honor, where a court pronounces itself on the bail conditions, the suitable person to enforce those conditions is the defense by nature of his position. So we find the sureties substantial, and we invite this honorable court to invoke its discretion to find him substantial. Your Honor, let me invite counsel Alan to respond to others.
Honor, for the record again, Sewaru Alan. And I wish you Honor to begin with the last objection, where the state objects and states that they are ready to proceed with hearing of the case, but because one of the accused persons has not been arrested, therefore it is still hindered in court. Your Honor, that is the very reason why we are applying for bail. Because the state seems to suggest that because the second accused person has not been arrested, and therefore she is not ready to proceed with the hearing, does that mean that our client is going to rot in jail? So, Your Honor, that should be actually one of the very reasons in support of our application for bail. Secondly, Your Honor, bail is a matter of urgent personal liberty. That, Your Honor, is jealously guarded in our Constitution under Article 23. When, Your Honor, a person is granted bail, does not mean that the case has ended. Your Honor, it is a temporary relief granted to a person to hear their case while coming from outside and not prison. But not a conclusion of the case on its merits. therefore pray that court considers that while Your Honor considering granting bail to the applicant, Your Honor. Your Honor, in rejoinder to the second objection, and Your Honor join this with the first. When my colleague was making an application for bail, he premised it on Article 28, Your Honor, which is a fundamental principle, Your Honor, in the criminal justice system of our country, the presumption of innocence. At this stage, Your Honor, the accused is only innocent until proven otherwise. We therefore pray, Your Honor, that court exercises its discretion while Your Honor considering all the grounds we have raised and be pleased, Your Honor, to grant bail. To the applicant, Your Honor, on very lenient terms like my colleagues submitted earlier on. Unless if my colleague has another rejoinder, he does not, we so pray, Your Honor.